stay?
No, we're not going down that road, Your Honor. Please. Once again, she doesn't have a dog in the hunt.
It's a dog.
Thank you.
All right.
We don't fight dogs anymore.
Gonna have PETA down here in a minute. Arbor One versus Rico McGuire. Et al.
Your Honor, Min Kim on behalf of Mr. McGuire, as well as all of the other.
All right.
Good morning, Your Honor. Deputy Gordon Lang here on behalf of.
All right. Where are we on these, man? Can I dismiss them and get them off my caseload?
We're okay with that. At this point, we, as we indicated last time before you, Judge, everybody that was on the docket has been no longer in a hotel. Everybody's been moved. Everybody's been relocated on their own or moved to alternate housing. So there's no longer an issue with any of those tenants. The property's actively undergoing remediation. We've still got the two buildings, 720, 721 West Clark, 720 Green. They are ready. We are still waiting for the city to allow us to have our COCs. Everything on the COC list has been done with the exception of two things. So the city is requiring Arbor One to do, which is still air quality testing, which we are before Judge Hunky dealing with that. They are also requiring us to place baseboard covers that are fully functioning, but for cosmetic reasons. And there's also an issue of remediation of 4 small areas in the unit that did not pass the build test. Those are the only things remaining in these buildings. We would, at this point, there are no health and safety issues from the property management team's perspective. So there's no reason these units should not be occupied, but the city is pushing back on that. So we have not gotten COCs yet. They've started the process on the next 3 buildings, 1431 LaForge, 1433 LaForge, and 772 Green. So they're working on those. Property management team says timeline from when we started should be 7 to 8 weeks. Could be less, half the time and half the money without the requirements the city is placing on us, but we work with what we're given. So they're actively working and they're moving down the list to the next buildings. So things are ongoing.
No. All right. So go, Ms. Kim.
Your Honor.
Yeah, go ahead.
I don't think it's correct that all the tenants have been relocated. I know that, for instance, Mr. McGuire is still looking for other housing. And I'm sure the court is aware of Judge Kunke's partial preliminary injunction, allowing the tenants some options to relocate.
But yeah, and I don't mean to interrupt you. Is that where there was the agreement that the tenant would sign that they would leave and then?
Correct.
Okay.
And I believe we had last had some emails with Anne about what the court required for the release of escrow, whether they can just submit the move out agreement, the court order move out agreement, or whether they have to file a motion with the court.
And I don't know I don't know how Ms. Wadling responded, or did we respond to you on that?
I think that you were waiting for a copy of the order, and
right, because I think that was right before a hearing. But so there was one case, I'm good. There was one case where what we did is the tenant came up, provided the agreement to us. It was signed off both by, I think, Beal and by the tenant. I read the agreement. The agreement made sense as to what it was saying. And so then I issued an order releasing the escrow pursuant to the agreement and attached it.
Correct.
That is how I thought all of the other ones that were going to happen that did that would take place.
So they do not need a motion. They just need to.
I don't, somehow or another, it has to be, they don't really need, I mean, I hate to go through the whole process of filing motions on it because it is rather straightforward. Just so you know, the young lady that did the other one, she brought it up to the court. Clerk didn't know what to do with it, got it to us. I read it and then I did the order. Okay, because I understood what was going on. Would I need a formalized motion? No, but would I need some way to recognize that we're receiving it? Because if it's what that person did, I'm going to issue the same order. I mean, it's not like we've got to reinvent the rule.
Tenants and the tenants union about what the court needs with that document. If there's anything additional.
No, but I just have to have something that says I'm submitting this stuff. You see what I mean? I mean, I can't just have loose paper flowing
Like
in.
a cover letter, you're saying?
Yeah, that's fine. And just direct it. Or if you know the tenants, they could just send, you guys could send us an email asking us to issue an order releasing the escrow. Okay.
And
I just want to make it as simple as we can.
Judge
And I
Simpson
just-
is doing something important here. He is separating a simple administrative request from a contested motion. The signed move-out agreement gives the court a concrete factual basis to release escrow, but the judge still needs a traceable submission, such as a cover letter or email, before entering an order. That protects the record and ensures money is not distributed on the strength of an unexplained piece of paper. Notice how the judge is reducing procedural friction without abandoning due process. For the tenants, that can mean faster access to funds. For the landlord, it preserves proof of exactly why the escrow was released. But a larger problem is already emerging. Counsel's claim that everyone has been relocated is immediately challenged by the assertion that Mr. McGuire is still searching for housing. That disagreement matters because a tenant's location, intent to return, and signed agreement may determine which order applies. Would you be comfortable releasing funds before those facts were confirmed? The court clearly is not, and that caution foreshadows the jurisdictional confusion ahead.
And I just wanted to add to Sister Counsel's summary that I just got an update from one of the city's attorneys this morning about the process of the administrative reviews, where those are. And apparently Arbor One lost the appeal to the County Board of Review, Construction Review. And also, I guess the other appeal before Judge Conti is still pending. And at the hearing on Friday, there was testimony taken about the air quality testing, and that evidentiary hearing is continuing on July 10th, I believe, at 9 a.m. And there was some discussion about whether there should be a neutral, not neutral, but I mean a outside third-party inspector involved in all of this. And a conservator was appointed last week. An order is about to issue soon. I think those are the additional updates that I can think of. There is one other concern, Your Honor. A lot of the people that were relocated by Arbor One to the villa side, are you aware?
Go ahead. I'm listening.
They're paying money into escrow as this court requested, and they're being sued for eviction in 14B.
Correct.
Court. And we are representing a couple of them, but it's a big concern.
I had talked to Judge Washington about that, right? Because now these cases are flowing over into various jurisdictions. Certainly, I think that those issues could be resolved in one of two ways. One would be to file with this court an order to either if all the issues are resolved, we would just pay out what's in our escrow to the landlord.
Resolve
Okay.
that way.
I mean, if the tenant's suing the landlord, the new landlord that's in the 14B jurisdiction, the villas, and all the issues are resolved, it's just an issue of money, then in order to this court saying that can be paid to the villas, I would sign off on something like that. If the issue is that there's going to be some litigation surrounding that, then it would seem to me to submit an order just requesting that this court transfer the escrow to the 14B district court on whatever that case number is.
I'm not quite following, Judge. So these are non-payment eviction cases where the tenants are paying their rent into court escrow here. So you're
Correct.
saying you want the escrow just transferred to 14B?
Either, well, there's going to be one or two things that are going to happen with the escrow. Either, well, I guess there's a third option. Either the escrow is going to be subject to the order that Judge Conkey issued regarding the distribution of that because that person has technically given up their other unit. So under that order, it may have to go to the tenant.
So under Judge Conkey's order, if you have asked Arbor One to temporarily relocate you, then
It's
you're not getting
50%.
a refund of the monies right now.
I thought it, as I read it, it was 50%.
They're supposed to be paying, if you're asking for temporary relocation with the intent of coming back to
Right.
Arbor One, placing a unit that has a COC, or when your unit gets a COC, whatever that winds up being, they should be paying 50% of their rent from wherever they're relocated to.
Right.
If they're being relocated permanently with no intent of coming back to Arbor One, and they're being relocated to a place that has a COC, there's no reason why folks should not be paying rent in a unit that has a COC. Judge Conkey's order is very clear that rent is only abated if there's no COC. So if these folks are intending on staying wherever they are, they should be paying full rent to Arbor One. And I will say, Your Honor, we are not handling the township side, so I can't speak to any of the actual.
Of course not, right?
File. But I would presume that if they're not paying the rent to the landlord and they're intending on staying there
Okay.
long term, that's
This-
why the eviction is filed.
I
And
disagree-
right,
I
that's, go ahead.
I disagree with what, first of all, there's nothing in Judge Conkey's order about paying 50% of.
Oh, no,
Yeah.
that's the way I read it. The agreement was that if they were voluntarily surrendering the unit without an intention of coming back, they would get all, for our purposes here at 14A, they would get all of their escrow. Right?
If they're giving up and not coming back.
If they're giving up and not coming back. The part I didn't know what to do with, because my understanding was there's this 50% split, is that if they went someplace else, I don't know what to do. There has to be an order or something submitted to the court as to what to do with that escrow. Because my understanding is there was this 50%, which I didn't understand, but it wasn't my order. There was the 50% split to, let me see if it's in this
There
tenant.
was some discussion, Judge, about the 50% because tenants who are placed in hotels had no way to cook their food, et cetera, but I don't think that language made it into the order.
It's not in the optional move-out agreement. I can tell you that much.
Judge Conkey was very clear on the record that her intent was to have residents who are requesting to be temporarily relocated pay 50%. She very clearly asked legal services, Blue, I believe, specifically, whether or not she would rather not include anything in the order with regards to temporary relocation and kind of let it be what it may, or consider or order that tenants pay 50% of their rent and make that decision.
It might have just been an oversight, but it's not in the order. But I would have to say that I believe the tenants
I don't
that are
know
in
that
your
that,
court are paying, actually, I think they were paying their full rent into the court escrow here.
correct, because we didn't, because the allegation that was raised was that they were being relocated by Arbor One to the villas in the township. There were issues that were raised as to the fitness of those units. Okay, I don't know anything about that. Those aren't my cases. So the tenant asked me, what should I do? I said, well, we have the escrow open. At that point, there's no case at 14B. I'm aware of that. So I said, just continue to pay your rent here with the thought process that could be that the financial pieces could be straightened out rather simply by virtue of an order. If they were sued in 14B and there's an issue, I don't know why you couldn't submit an order to the court just asking us to pay those funds over to escrow and 14B.
So from what I understand, Judge, the tenants that have been relocated to the villas, some may have signed leases to stay there permanently, but the tenants that we're representing, they're there temporarily until their units get their certificate of occupancy. They're in.
Okay, that's fine.
They want to be, or their conditions aren't right, or for instance, there's another tenant who's.
Well, what are you asking me to do though?
I'm not sure what the right thing is, Your Honor. I don't know if 14B should have jurisdiction over those cases in a non-payment case when they have been paying rent. There shouldn't be a non-payment eviction filed at all.
And that may be, I agree with you in the sense that that may be your defense to their claim. When they filed the case in 14B, your defense of that is they've been paying their rent all along, right? It just happens to be here because they got relocated there. So the way to resolve that, it seems to me, is in one of two ways. If those folks are going to be coming back, would be to take the escrow I have here, get an order to send it to 14B to be held as escrow on that case. That would seem to me to be the simplest thing. And then that has to be litigated over at 14B.
And then what would happen to their case here? Would it be stayed?
Why would I stay that?
I mean, they have counterclaims. It's not just about the rent being paid, as you know. These people that Arbor One did not have the right to collect rent since September 17th.
Correct.
In some
So
aspect, they should just get the escrow released to the tenants.
I don't have a problem, even if you do the math, with that concept of it coming back to the tenants, if that's what Judge Kunke ruled. I don't have a problem in that. But there's a point at which they're now in the township, right? They moved. And I don't know that these folks, but you're saying these are not folks that have signed leases. These are people that are just temporarily housed there and are coming back. So let me think about that a second. It would seem to me that those folks that are temporarily housed there and are coming back, that I would release or do whatever with that escrow consistent with whatever Judge Kunke's ruling is.
Judge Kunke's ruling and the move-out agreement with regards to the release of escrow are specific to the folks who are entering into this move-out agreement. These folks that Sister Counsel is talking about are not subject to move-out agreements. There's three options that folks can select. They can select the move-out agreement,
Right.
break their lease, and they receive a refund. They're gone. They're finding their own housing. They're leaving. They're doing that. Folks can choose to stay in their units because, quite frankly, a lot of these units have been turned and are perfectly fine, and they are just choosing to stay. Or folks have the option.
And let me ask that. So if they stay, they pay rent?
People who are staying are
Whatever.
electing not to pay rent. There are folks who are voluntarily paying rent because they have some sort of other obligations that they recognize, whether it be some sort of assistance or just recognize.
Whatever. Okay.
So, or there are folks who can elect to be temporarily relocated by Arbor One, with the intent of coming back when they can be placed in a COC, a unit with a COC, or their unit gets a COC. So the release of the escrow portion of the move-out agreement is only for those folks who are entering into those move-out agreements. There's been no discussion about release of escrow or anything of that nature with regards to any of the people who are electing the second two options. So I'm not sure why we're talking about escrow with regards to the folks who are temporarily relocated, because they're not even subject to that issue.
Well, right. And so
I don't disagree with what she's saying, Your Honor, but I think that transferring the escrow to 14B means that Judge Washington will be hearing all of the same issues that this court is hearing, and it doesn't.
welcome to the wonderful way we've set our courts up.
I think that I mean, I might have to confer with my team, but I think that the 14B cases should probably be dismissed because they are not really not paying their rent.
Well, and
And-
I may, let me, for those that have not signed a lease. So if they move over into 14B, sign a lease, then, and they have escrow here, then this move out agreement is what would apply, right? Because they permanently relocated, they said, I'm not coming back. If they moved over and it's a temporary housing until there's a CO, I don't even know how a case is being filed against them.
That's what we're saying, Judge.
But that's not, but hang on a second. That's not my call to make. I mean, if it were before me under the circumstance, I could tell you what I do, but Judge Washington may have a different view of it. And that is, I'd say, well, they're coming over here because their unit is not what it is. So I don't know why you're here asking for non-payment. Because really everybody's just hanging on to these cases because your unit isn't up to date.
And
That, I mean,
there are motions that are going to be heard on July 9th on this issue with Judge Washington.
so you guys have managed to get at least 3 judges
I mean,
involved.
I'd rather just be in one form, Judge, and I'm renewing our request to stay all of it.
These cases?
Yes.
Well, I think what I'll do is I'm just gonna give another date, because so let me just throw something else out there so that everybody knows also why my life becomes difficult. There are tenants who are Arbor One tenants who have relocated to other complexes outside of the villas that are within my jurisdiction, who are now also before this court by their new landlord for not paying rent. It seems that the landlords and the tenants are aware of their circumstance. But I don't know what posture is being taken with regard to the new landlords. And some of these new I think the ones that I just heard, I think they're all Beal properties.
Okay.
But I don't know under what circumstance. There were, I think, 2 individuals this last docket. I don't know under what circumstances they went. So I don't know if they went and it was a temporary thing and then they were going back.
Anybody that was relocated outside of the villas was not, my understanding, though, the only temporary relocations that have occurred have been to the villas. I don't believe that anybody.
I don't think that's correct. There was a order, Judge, where you said any Beal properties portfolio, properties available in their portfolio that they were transferring them to as well.
Well, I don't know that I mentioned anything about Beal properties. The only thing I mentioned was the villas, because I knew they were going across the street to the villas.
But Beal properties opened up their portfolio to the tenants who want.
Yes, I recalled that happening.
And those folks have been signing leases, is my understanding. So those have not been temporary relocations.
I think that.
And see, here's my problem. I hear what you're saying. I don't know that.
Another wrinkle, Your Honor, I think that tenants who signed leases may have felt like they had no other option if they wanted to stay in that new property. If you recall,
I remember.
Beal was making them pay application fees and new security deposits and having them sign leases. And I don't know if the tenants were aware that they could refuse to do so. If you have the names of the-
I had 160 cases. I don't remember those 2. You do? Okay, well, then we can get those to you. But I don't know what the status of them is. And now I have this other landlord involved, but I don't So I'm not sure what to do with those, and I'm not sure how many there are out there. But it would seem to me what Counsel's indicated makes sense, that if they're in these other places, they may have signed a lease.
That's my
And I'll tell you, Ms. Kim, that's what I assumed until you said what you said this morning about the people in the villas getting sued and they didn't really sign a lease. So,
We have to contact these tenants and, if they're a client with us and see what's going on.
right. So on these cases, what do you guys want me to do? Because
Judge, honestly, we would request to stay until there's a decision by the circuit court on, whether, when they get a certificate, they determine how much rent they owe, if any.
well, hold it, but this is what makes this so bad. Once the circuit court gets done, and maybe I'm wrong, I'm presuming that they're going to go through for those tenants that dispute as to what rent is owed. Is all that stuff coming back here? Because if it is, oh boy.
Ideally, Judge, would be a overall settlement so that you don't have to, look at every single individual case and there'd be a global decision.
I mean, we see no reason to
From your lips to God's ear, but I don't know.
continue to keep these cases. I think there's obviously a question of money being held in escrow and what's happening with that, but outside of that, I think
these cases run their course, we should dismiss them.
Well, I get that, but you also maintained that from the beginning. But
I'm concerned.
exactly. But what I'm hearing from Ms. Kim is there would be basically a general objection to that because there may be claims, but
There are some cases with counterclaims.
yes, there are.
The proper thing would be at some point to remove them to circuit court. And we can certainly continue this conversation between us, amongst us, about whether we should just dismiss all of these. But at the moment, we would ask that they be stayed.
Well, in part of my problem is this. I can't dismiss all of them because I don't have a disposition of the escrow.
I guess I was under the impression that she meaning Judge Funky had taken jurisdiction on the escrow.
I don't know that.
I mean, I think at this point, the only reference to escrow was in the move-out agreement. There's been no other discussion or disposition of the escrow other than them being able to apply to this court, or if they're subject to a move-out agreement, for court to determine whether or not to release their escrow. And,
Right.
And we've had one of those requests so far. And
Are you
obviously,
talking Ms. Gamble?
yes.
Yes.
What you entered the order for. And then I believe there's another motion later today, but she's not subject to the move-out agreement as she moved out prior to any order was entered. So that's a totally different situation and request. And so from our position with regards to the escrow, and you'll hear this later, the escrow should be released to be accessible to the landlord for remediation by statute. Your Honor already got it correct by ordering these tenants to put the money in escrow. And so, you've been taking the position that we have to determine what's going to happen, and that will happen at a, later date. We're maintaining that this property is actively undergoing remediation. Statute is very clear that says if there's no CFC, tenant should be paying into escrow, and that money should be used for the purpose of remediation.
It can be, right.
Yeah, and so if we're getting to dismissing these cases and dealing with the escrow, that's, what the escrow should be used for in our position, so.
But I don't know, and maybe or maybe not agree with you on that. I don't know what tenants are still there.
And that would impact whether or not the escrow was released for remediation purposes or.
Right, so Frankly, I don't have enough information because I don't have the whole case. So I don't have, I may have a tenant that has escrow in here. I'm unclear what to do with it because I don't know, should this tenant be subject to the move out agreement? Have they voluntarily done whatever? Are they just temporarily there, either by virtue of Arbor One putting them there? Or did they kind of voluntarily move themselves temporarily and they're intending on coming? I don't know. And I think those things, the escrow, what to do with the escrow becomes different as to what to do with the escrow just on those scenarios. And I'm sure there can be more. But Mr. Friedman, if you're saying Judge Kunke took jurisdiction of the escrow, I'll send it all up to her. I'll be good.
I'm not sure she did. I'm not sure she did. Frankly, to be blunt, some of it's kind of confusing because she's saying it can be used for this, and she, in a sense, she took jurisdiction over the escrow because she said what it can be used. She said that it can be used for certain purposes. So,
you mean in terms of remediation of the
So
unit?
I believe Mr. Freeman's referring to the terms of the move out agreement.
Got it. Yeah, so I don't have any problem. Once I saw the move out agreement, like I said on the Miss Gamble, I don't have any problem dealing with it, how I dealt with it, of just issuing the order once I had the signed agreement and we attached that to it. Didn't have a problem with that. That's the only case I've done.
Yes, Judge. There are people I'm sure moved out before the order was issued and
Before which order?
Judge Kunke's order. And unfortunately, those tenants, they can't access the benefit of that agreement. Maybe we could can I propose it?
Because they
Moved out prior to, the move out agreement is specifically for folks who are currently at Arbor One, who wish to break their lease and leave to find their own alternative housing. And so if somebody's vacated months and months before, they can't now come back and say, oh, I now want to enter into a move out. They've already moved. It's a move out agreement for folks who have not moved and are still at Arbor One. So there are folks who have already been relocated or who have already decided to leave on their own. And so that money and if there's being held in escrow, it's our position that should very clearly be used for remediation purposes. With regards to the folks who are submitting move out agreements currently, who are planning to leave Arbor One and who are currently residing there, I can understand, Your Honor, that could be a different situation as to looking at what's to be done with the escrow. At the end of the day, our position is the statute is clear. Any money that is being put into escrow with regards to somebody who is living at the unit when there's no CFC, that money should be directed to remediation. And so, quite frankly, it's kind of all encompassing with regards to the statute. The statute trumps the ordinance, which says that they are not required to pay rent with no CFC.
Your Honor, I disagree with the interpretation of the preemption issue, which I think was part of Arbor One's motion recently that Judge Kunke heard on Friday, and it was denied. The preemption issue, because the city code says something else, and there's a statute that says that the municipalities can have a higher standard or more protections for the tenant. So we're not asking the court to rule on that today.
And I'm not going to.
And counsel keeps remediation, but I think that most of their funds are going through litigation, honestly. And
not by
they have said many times that money is not an issue with making all of the repairs in objection to having a conservator. So I think the little bit of escrow that this court is holding right now is just tiny little pennies that will not really make that much of a difference in their remediation efforts. That's just my opinion, Judge. But I would ask that you give us an opportunity. We can come back to talk about potentially dismissing these cases, but we would have to deal with the cases.
You're coming back
with counterclaims.
I got you. And I think what I'm going to do is I'm going to give you a date into the future let all of this sort out. I am always available if you guys have resolved certain things to it, if you resolve a particular case, I don't have a problem issuing an order doing X, Y, and Z. I mean, I'm not going to have an issue with that. One other issue do I dare say, so I'm going to need something about a month and a half out of place. There is this large monies that I had, or large, relatively speaking, in this case, like 50, 60,000.
About 65.
65.
Yeah.
So did we?
I have reached out to the city's attorney to inquire on several occasions about them submitting something to the court pertaining to what that money will be used for. We would like it to be used for inspections fees pertaining to these two buildings and applying those. I've got nothing back. At this point.
Okay, well, something has, all right, no, I hear you. And something has to be done because those funds were paid in good faith because there was this rather bizarre notion that there were bills that weren't paid, so they couldn't move forward. And so I said, well, how many bills do they have to pay? And what are the bills? And they couldn't give me what the bills were. And then an odd thing happened that really does bring it to light in my mind. The amount that was owing on those past bills, typically I would have thought that Arbor One would have given me a lower figure that was owed, as opposed to what the city was saying. But the city gave a lower number. Arbor One gave me the 65 or whatever it is. They paid it in good faith. Since it was taken in under those circumstances, there needs to be some. They said they couldn't take it and then apply it to what bills, which was bizarre to me. But I thought I was going to get a list.
And we've asked for that. I've got emails to the city attorney asking them very specifically to ask their client to prepare a list. It's become incredibly problematic as of this week as well, because we've got this money being held that we would like to be used for fines. And the city has now filed 40 some liens against us for fines. And so that's happened as of this past week. And so this is, the type of things that we were hoping to avoid. And so now we have to deal with that because the city won't get back to us about, and this is, and like I said, we're moving on to the next 3 buildings. And so we're trying to get this going, but we can't even get the money applied for the 2 that we're dealing with now. And so that's been an issue. So I don't know what more Arbor One can do with regards to reaching out to them, because that has to come from the city. We've made their request as to what we would like it to be applied to. But yeah, I mean, I can reach out again today after the hearing and indicate that.
Do you have, that the number you gave counsel, I'll tell you what I'm going to do. We'll just do it this way. When you paid the 65, whatever you had certain bills.
Well, they actually had returned checks, if you remember.
Correct.
That were good.
So yes,
we're talking about NSF checks. We're talking about checks that were not stale.
$50,000 checks. So yes, we had numbers. We were able to pull from the BSNA website or pull from our own records and see what was due. So we could, if the city's not going to do it, in order to get the money, we can pull the numbers together for these 2 buildings and see.
Here's what I'm going to do. I think yeah, go ahead.
I just feel like releasing the money to Arbor One.
No, it's not. No, that's not. It's going to the city.
But Your Honor, that is going to the city for payment of Arbor One fines, right? Is that what we're talking about?
They're inspection fees, which is why I took it in the first place. I mean, I don't know if you were at that hearing, but it was bizarre to me what the city was saying to me. The city was saying, we will not do any more inspections because they haven't paid these fines and whatever in the past. I said, okay, well, how much do they owe? And they gave some figure. Hold on. No, you need to hear this because this was bizarre to me. And then I said, well, if they each had a number, and I said, well, just pay it to the city and they can sort it out and apply it to whatever bills are owed. They then said, oh, we can't take money that way because they don't want us to. They don't know who they are and what that meant. So then it ended up that I took the higher number.
It was the number plus 20 or 25%. It was 20, I think it's 25% over the number.
Whatever number it was. Anyway, that I took that in and I said, okay, with the thought, get me the bills that need to be paid, get an order, we'll release the checks, those will be paid to not hamper further inspections on the premises. That was the intent.
I guess, Your Honor, what I'm trying to say is that these funds belong to tenants.
No,
They do not.
no, these don't belong to the tenants.
Until it's litigated or.
No,
there's a decision
these
made.
funds don't belong to the tenants.
She doesn't have a dog in this hunt.
Yeah, I know. The funds that we're talking about, Ms. Kim, are not tenant paid or landlord paid escrow
Oh, okay.
for that.
What-
It was taken into escrow so we could, just understand this. So that the bills and fines that the city was complaining about could be paid so that further inspections could happen. Because the city would do nothing unless this was paid.
But the funds that we're talking about, are they not escrow funds from the tenants?
No,
Oh, okay.
no.
what are the source of these funds that we're talking about?
These were the landlord's monies that they were going to pay to the city of Ipsy that the city of Ipsy wouldn't take.
Privately held money from the landlord.
Got you. So we're not talking about tenant escrow at
No.
all?
This
Okay, we
exchange
will-
exposes the hearing's central problem. Several legally distinct pools of money and several categories of tenants have been discussed as though they were interchangeable. Tenant-paid rent escrow may be affected by occupancy status, a move-out agreement, counterclaims, or Judge Kunke's order. The roughly $62,000, however, came from the landlord for city bills, fines, or inspection-related charges. Once Judge Simpson identifies that distinction, the tenant's attorney's ownership objection loses relevance to this particular fund. Did you notice how quickly the judge's tone sharpened when counsel continued asking about tenant money? That reaction reflects more than impatience. A court cannot responsibly distribute funds until the source, purpose, and intended payee are established. The judge's solution is procedural rather than ideological. Require a documented allocation, submit it under the 7-day rule, and allow an opportunity for objections before disbursement. That creates an auditable record while preventing the money from remaining frozen indefinitely. Strategically, the landlord's counsel helped by explaining the return checks and inspection delays, but still must produce a precise bill-by-bill accounting.
No, not at
Okay,
all.
we've moved along. I'm sorry, Your Honor.
We did that about an hour ago. Nice of you to catch up. All right.
Glad we're on the same page.
No, I bring it up because I need I'd like to dispose of that.
We can get, yeah, that would be.
So here's what I'm going to do. I'm going to order that the parties that I have before me are to provide me a list of how those escrow funds are to be dispersed and to what bills they should apply at the city of Ipsy. You're to do that within 10 days.
This is not tenant escrow.
This is not tenant escrow. This is the funds that we're holding for the payment of that,
And how much is being held, Judge?
about 65,000,
The dollar amount on that big check was 62,000.
62,000. All right.
And can I ask if the court knows how much tenant escrow is being held here?
We absolutely do. Give it to me, please. There's an additional 10 though.
Yeah.
So it's going to be 21,590, right? Or there.
590, Your Honor?
So the plaintiff also
Had
had, right,
Right.
correct. Yeah.
okay,
And then
so
this is
we're at about
specifically
20, right?
And are tenants continuing to pay for escrow right now?
I have no idea. I don't know when the last payment we got. We updated it occasionally, but. Okay. what I have is I have about 84,000 that I'd like to dispose of in some fashion. 62 of that being what was paid to the bill. So I'm ordering, let me just get back to that. I'm ordering that. That's to be submitted within 10 days. And I'd suggest, let's do it this way. Submit it under the 7-day rule to me.
Both,
No, for the 62.
but you want both of us to submit a 7-day?
No, no. Really, Miss Kim, you're not in, the tenants aren't, the tenants really weren't involved in this.
We can,
This 62 was paid by we were looking to get repairs moving and inspections moving. The city said, and I'll just say it again, the city said they could not do inspections because they haven't paid this, whatever. So I said, well, how much is owed? We came to a figure. I said, well, go ahead with the inspections. Now the court has some money, right? I don't know that that's occurred, but anyway, I had the money. I then asked the city the last time they were here to basically give me a breakdown of what bills it should be applied to because they said they couldn't take the lump sum and do it themselves. Okay, I've got nothing. So now I'm ordering parties to give me something, file it under the 7-day rule, and then those particular funds I'm going to disperse for that purpose. That's what I'm going to do. Because
you said under the 7-day rule. Okay.
Yep.
So not 10 days.
Well, you have 10 days to do it, but submit it under 7. Well, however you want to do that, because there's different reading of that rule.
Okay.
I'd like it sooner. I'd like it sooner than later.
It's beautiful.
I will just note one other thing. I just
No, go ahead.
knowledge. I believe that Ms. Kim mentioned that she received information that our appeals had been denied by the Board of Appeals, which we did appeal the red tags to the Washtenaw County Board of Appeals. They did deny those, but we've appealed them to the State Commission, and those are pending.
Got it.
So that is still all in place. No decision has been made. I believe the meeting for that are July and October, respectively. So we will be dealing with those accordingly. And as Ms. Kim also mentioned, Judge Kunke on her own mentioned to the parties on Friday about sua sponte, ordering a independent third-party inspector. We've been making our claims to her that, there's a lot of stuff going on here with, disparate treatment. So seems like she's hearing that. And so we're briefing to her by Thursday her authority to do so, and why that would, substantially benefit the process of getting these buildings online. So that's being briefed to Judge Kunke by Thursday. And so, yes, I think that was all of the major updates here.
All right, real good. Then what I'm going to do, other than the 62,000, I'm not going to do anything at this point with any of the escrow, except as is consistent with Judge Kunke's order, if there's a move out. Right? Otherwise, I'm not doing anything with it unless the parties agree that it be sent someplace else. I'll get that other order and then we'll adjourn this to all of these.
Tuesday, August 12th at 9 a.m.
Tuesday, August 12th, 9 a.m. And then we'll see where we are. Okay?
Thank you, Your Honor.
Thank you.
Enjoy your summer.
Huh?
Enjoy
Check
your
that
summer.
date really quickly, Your Honor, if you don't mind.
It's too late. I'm not going to enjoy my summer.
That Tuesday, August
12th. Yes,
Okay, that works, Your
it
Honor.
works. All right, fantastic. All right. Thank you, folks. Did they have an order?
I'm sorry?
Those two, did they have an order?
Yes.
Where is it?
Also the motion. I didn't know if you were addressing it. No.
Oh. There is a motion, another motion.
Yeah.
Let me get this order here.
Yes.
Yes.
To use that info for Your Honor, that may have something to say. Or
No. We're not going down that road, Your Honor, please. If she won't file an appearance and she wants to, it's not appropriate for her to interject herself into this without being on the record, period. I'm not. Once again, she doesn't have a dog in the hunt.
I've signed this. We'll get copies to you.
It's a dog. Thank you.
All right.
We don't fight dogs anymore.
Right. Gonna have PETA down here in a minute.
I know when the motion was submitted, there was submission statement that she's not representing. That's based into my knowledge on. It's being submitted for her, but she's not represented by counsel, so we're prepared to move forward with.
Is she here?
She was in this. She's possibly dial-in.
Hello,
We have one.
Hello, what's your name?
Denise Llewellyn.
Okay, Miss Llewellyn, I guess I'm gonna do it this way. Are you intending on being represented by counsel?
Yes.
Pardon?
Legal aid. Sign was legal aid.
Yeah, okay. Are you guys gonna represent Miss Llewellyn and file an appearance and answer?
File an appearance and do not intend to represent Your Honor. But we are very familiar with the situation, and if the court has questions, I'd be happy to.
Yeah, but Mr. Friedman makes a good point. I mean, I don't know who's, from the court's perspective, I don't know who's answering back. I mean, it's sort of, I'm getting these sort of phantom arguments, and it can't operate that way. More importantly, Miss Llewellyn, I mean, in fairness to her, I think she believes she's being represented.
I've
But
been dealing with this since
Pardon?
court started. I said I've been dealing with legal. We've been started almost a year ago. with
Okay,
Arbor
you broke
One,
up there.
know.
Say that again, Miss Llewellyn.
I said I've been talking to legal aid since Arbor One been going to court. So I thought I was represented because I've been talking to them. I've been emailing them. They've been emailing me back. I don't understand what's going on now.
I believe that Ms. Llewellyn was.
May I approach?
Because I've been trying to break my lease.
Okay, hold on, Miss Llewellyn. Come on.
Okay.
Okay, folks, in this matter, record should reflect, we've had a brief bench conference. Miss Llewellyn, I'm going to adjourn your matter to July 8th, 2025 at 2 p.m.
Okay.
Okay? During that
Okay.
week or so, I need you to talk to legal services. And my purpose in adjourning it is so that there's a clarification on whether or not they are representing you or whether or not you are going to proceed on your own.
Okay.
All right? Thank you.
All right.
Thank you, Your Honor.
Thank you, Your Honor.
Judge Simpson avoids a sweeping ruling because the record contains too many unresolved variables. Some tenants may have permanently relocated and signed new leases. Others may be temporarily housed and intend to return. Some possess counterclaims, and Judge Kunke's separate order may control particular escrow releases. Rather than dismiss cases and risk losing control over disputed funds, the judge keeps the matters pending until August 12. He also declines to move tenant escrow unless the action is consistent with Judge Kunke's order or agreed upon by the parties. That preserves the status quo, while parallel proceedings and jurisdictional questions develop. The ruling concerns approximately $62,000 supplied by the landlord, not tenant rent escrow. Judge Simpson orders a proposed allocation within 10 days, submitted through the 7-day rule process, so the money can be tied to identifiable city obligations before disbursement. The final exchange involving Denise Lou Allen reveals a second due process concern. She believed legal aid represented her, while counsel said no appearance had been filed. By adjourning her motion to July 8th, the judge prevents her from proceeding under a mistaken assumption about representation. What should viewers take away? Escrow is not one undifferentiated pot, jurisdiction matters, and even a payment order requires a clear record showing whose money it is and where it may legally go. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.